Can we follow this? Can we follow? Can't.
The same problem. Yes, it's okay.
It's okay. It's okay. 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 Exactly. It's okay. Okay. Good afternoon, everyone. It's nice to meet you all here. Please introduce myself. My name is Retno Widiastuti. I'm from Faculty of Law, Gadjah Mada University, Yogyakarta, Indonesia. And today I'd like to present my paper about optimization of modern courts in Indonesia. Okay, table of content, introduction, method, analysis, and conclusion. This is introduction. What is law? From Black's Law Dictionary, a body of rules of action or conduct prescribed by controlling authority and having binding legal force, that which must be obeyed and followed by citizens subject to sanction or legal consequence, is a law. And what is function of the law? By Lauren M. Friedman, law is to social control, dispute settlement, social engineering, redistributive, or innovation. And in a nation, the law can serve to keep the peace, maintain the status quo, preserve individual rights, protect minorities against majorities, promote social justice, and provide for orderly social change. Law can be used as a learning medium for the community. Indonesia, as state law, has written laws and has several law enforcement officers, one of which is the judiciary. In Indonesia, judicial power is regulated in Article 45 on the 1945 Constitution of the Republic of Indonesia. The main is the judicial power shall be independent and shall possess the power to organize the judicature in order to enforce law and justice. The judicial power shall be implemented by a Supreme Court and judicial bodies underneath it in the form of public court, religious affairs court, military tribunals, and state administrative court, and by constitutional court. And the other institution shall be regulated by law. So this is authorities of Supreme Court. The Supreme Court in Indonesia shall have the authority to hear a trial at the highest or cassation level, to review ordinance and regulation made under any law against such law, and shall possess the authorities as provided by law. And this is authorities of Constitutional Court, again by the Constitutional of Indonesia. The Constitutional Court shall possess the authority to try a case at the first and final level, and shall have the final power of decision in reviewing laws against the Constitution, determining dispute over the authorities and state institutions whose power are given by this Constitution, deciding over the dissolution of a political party, and deciding dispute over the result of general election. This is the authorities of Constitutional Court. So, along with the times, the judiciary in carrying out its duties must be able to reach the needs of the community, especially in conducting trials. As it should be, the court must be based on the principle of low cost and easy access. The development of information and communication technology has a major influence in various fields, one of which is the field of law. So this can be seen with the application of online justice. So based on the background of the problem that has been described previously, the formulation of the problem in this research, or my research, is how optimization of modern court in Indonesia. The methods, the study in this research is normative, The technique of collecting legal material is done through a literature study. The literature study was conducted by reviewing the legislation and related literature. The research used a stationary approach, a conceptual approach, and a case approach. The type of data used is secondary data with qualitative data analysis. So this is e-court. This is e-court of Supreme Court. They have the electronic justice system. Call it with e-court Mahkamah Agung Republik Indonesia in Indonesia. So what is e-court Mahkamah Agung RI? Is a service for registered user for online case registration, getting online case fee estimate, online payments, summons made by electronic channels, and courts conducted electronically. They have e-billing, e-payment, e-summons, and e-litigation. So the e-court of Supreme Court is regulated in Supreme Court Regulation number 1, the year 2019, and number 3, the year 2018, about electronic case administration and trial court. So this is e-court of Constitutional Court. They call it with electronic handling information system, and the name is simple MKRI ID. Electronic application can be submitted online in real time instantly through simple electronic media, which is a web-based application that is part of Simple to provide direct access to parties to constitutional cases, including to submit electronic application online or online application. With Simple, parties or the public can register themselves so they can submit application online, monitor the progress of application cases, and access various service features such as trial schedule, court calls, downloading minutes or decision, and online feature. And e-court of the Constitutional Court is regulated in number 1, the year 2021, about remote court. Modern court are used to implement and realize the simple principle, the fast principle, and the low cost principle. When the government is going to actualize legal policies, what should not be forgotten is its law enforcement instrument. According to Black's dictionary in Ansori, a law enforcement is the act of putting something such as a law into effect, the executive of the law, the carrying out a mandate or a command. E-court law enforcement instrument in the administration of justice in Indonesia, legal structure, legal character, and legal infrastructure. The application of modern courts should take that into account. Thus, in practice, modern courts encounter several problems. This is the challenge or weakness of modern court in Indonesia by my research. First is the presence of a modern court can indeed represent a simple principle through online trials anytime and anywhere. However, modern court have not fully resolved cases received by the court, both the Supreme Court and the court below it, as well as the Constitutional Court. This means that most cases are still carried out conventionally. And regulation regarding e-court or modern court still have legal problem and have not fully accommodated the sustainable implementation of e-court. Regulation of online court is also more severe during the pandemic. In terms of the legal structure, institution, and law enforcement in the realm of the judiciary, they are still administrative problem to procedural deviation. In terms of legal culture, especially the use of modern court is increasing, but this is still not proportional to the amount of caseload receiving by the court. In terms of facilities and infrastructure, in certain areas, the lack of facilities and infrastructure make judicial seekers still spend a lot of money due to the inadequate facilities and infrastructure. So, based off the problem, optimization of modern court in Indonesia can be by this way. This responsiveness can be done through firstly supporting regulation and optimizing online court or e-court. Regulation is in a sustainable manner, strengthening service in judiciary by building synergies between stakeholders, strengthening supervision, and maximizing the performance of court officials and improving infrastructure in researching the court. Conduct outreach and education to the public and law enforcement. Thank you for your attention. The author, me, gratefully expresses her gratitude to LPDP, Lembaga Pengelola Dana Pendidikan the Indonesian Republic, Faculty of Law Gadjah Mada University, and Highcon Law Firm, which funded this research. So this is my presentation today. Thank you for your attention. The secure adhering.